So in civil trials, it starts out like this. The process is that you file a complaint with the court clerk, you give notice to the defendant replies, there's a court hearing, then they go into discovery. What is discovery? Discovery is when both the defense and the plaintiffs in a civil case or prosecution in a criminal case presents each party with whatever evidence that they have regarding the case. And that is exchanged between the parties to be able to build a better picture for the fact finder. So once that discovery happens in civil court, there's court hearing, you can decide to settle, the court can look at the evidence gathered, and then one of the moving parties can say that there's not enough evidence for us to move forward to a trial, therefore it must be dismissed. If the court agrees with that, it is dismissed. If there's a settlement, there's a settlement. So if there's not a settlement, if there's not a dismissal, it goes into trial. If there's a jury trial, there's jury selection. At trial, there's presentment of evidence and witnesses. The judge is the arbiter of what evidence comes in for the determination of the trial and determination of the facts based on rules of evidence. Then the opposing parties have the right to cross-examine their opposing witnesses. And then the jury or the judge, depending on if it's a bench trial, which is judge, or a jury trial, which the defendant gets to pick, there will be a verdict. And the verdict is either the defendant is liable or not liable, and then there's an appeal from that.